this is Court Watch with Alex Swoyer, and I'm excited to bring you the latest episode of my podcast where I am joined by Josh Blackman, a professor at South Texas College of Law. Josh is an expert court watcher who I have spoken to a number of times throughout each Supreme Court term as I have covered the justices during the span of about 7 years. I noticed he was in the courtroom during the justices' hearing in October over the regulation of firearms kits, or what he says critics call ghost guns. The justices appeared sympathetic to the Biden administration's attempt to regulate the gun kits that contain parts that, when assembled, make a firearm. The Biden administration says because the ghost guns lack serial numbers, they have been used more and more to commit crimes. In 2022, the federal government tried to regulate the kits by requiring them to have serial numbers. They also now require a background check for purchase. Companies that manufacture the kits have challenged the regulation. They say the new rule runs afoul of federal law, with the feds trying to regulate the relatively new technology under the 1968 Gun Control Act. The justices have allowed the rule to go into effect while the litigation is pending. I'll have Josh join me to break down how he thinks a ruling could come down. I saw that you were in the courtroom for oral arguments over the federal government's regulation of ghost guns. I couldn't get across the barrier to come say hi, but I wanted to pick your brain, knowing that you've followed this issue for years now. And what did you think of the arguments and the justices' questioning?
Sure. And just to be clear, I'm actually the lawyers in this case. I represent Defense Distributed, which is one of the parties that's being regulated. You know, I think this is a tricky case. Because the government has sort of interpreted federal law in a way to allow these sorts of devices and kits for a very long time. Congress hasn't changed the law, but the Biden administration saw a problem. They said, okay, well, we need to make a regulation, and we need to deal with these types of kits and frames and receivers that people are manufacturing at home. The argument, I thought, went probably about as expected. But what's sort of important to remember is this is not really about trying to facilitate bad guys from having guns. That was some of the thoughts that came up from the argument.
Right. That was kind of what the theme was from the government, right? That these don't have serial numbers and that it means that they're used in crimes.
Right. There's a tradition going back to the American Revolution of Americans making their own firearms, tinkering, designing, innovating. And even in this case, the people involved are not criminals. They're law-abiding citizens who are trying to have the right to make these kits. The government says, well, if you want to make a gun at home, just go through a background check and so on. That's a nice thought, but this rule will put out of business all the companies that want to make these kits. It's not profitable to sell these marginal things with having to go through background checks with very expensive requirements to maintain. So this will put hobbyists and people interested in making guns in a very tough spot. And if there's only one thing that the court didn't quite get, I think it's the importance of this people who are not bad guys, that there are law-abiding citizens who have an interest in making their own firearms for lots of reasons. There's one instance where Chief Justice Roberts said, it's not like building a car on the weekend. Well, it kind of is for a lot of people. People do like to tinker and make their own devices. And I think they sort of lost that thread during the argument.
Yeah, I think you're right. And then also, so that was a question from the Chief Justice, and then also Justice Barrett kind of chimed in, and she kind of took the approach, at least I was gathering from one of her questions, I think it was Justice Alito mentioned, he compared it to buying ingredients to make an omelet, but you don't necessarily have an omelet, you just have ingredients, right? And then she kind of tried to suggest what if it's a kit from HelloFresh, so I kind of got the feeling she might be a little skeptical too. What was your thoughts?
Well, look, I think Justice Barrett is the justice who it's sort of easy to figure out what she's thinking. Some of the other justices often play close to the vest. Justice Barrett doesn't. And, she came out pretty early, and she refers to them as ghost guns. And that's not a term of the statute. It's not a term of the regulations. This is a term that critics use. When you sort of use the language of one side, sort of signals which way are you thinking about the case. But again, I don't think the justices fully understand the sort of culture and tradition behind gun making, and they were sort of just fixated on this as for people who are of bad intentions. They also probably, I doubt any of the justices had ever made one of these devices. The Solicitor General, the government's lawyer, Freelogger, She said that she made one of these kits. I don't doubt that someone told her where to drill the holes in these frame receivers. I also don't know if she actually tried to fire it. It's actually very hard to do this correctly. In fact, there are a number of liberal journalists who have tried to do this over the years and said, wow, yeah, we drilled the holes and it didn't work, which is not surprising. So, the government lawyer said she did it. Who knows if it actually even worked? Yeah, this was not about actually indicating the real process. You say, oh, look, I did it. Wasn't that bad?
Yeah. I remember, I think there was was it 60 Minutes, or there was some sort of a video that where the supposed firearm expert wasn't able to do it, right? I think there was something that was out there that it wasn't, this easy to put together. It wasn't something that I guess they were trying to make it sound like you just drill a hole here and that's it. But I guess, are we expecting this one to be a case that we're not going to get probably until closer to June, the ruling?
How do I answer this question? As one of the lawyers. The general rule of thumb is the cases that are more divided take longer, and the cases that are more lopsided take shorter. So if this is a case that the justices are not particularly divided on, it will probably maybe come out earlier in the term. If the case is more divided, it will take longer. I'll just leave it there. Let
me ask you, on the November docket, you and I kind of emailed, and there's no, case like this that a lot of people were watching. I guess I shouldn't say, there's important cases, but for a wide-ranging audience, I didn't see anything necessarily to dive deep into. And there's 3 days where the justices only have, I guess, one case that they're hearing instead of 2 scheduled. So I guess my question to you is, why do you think the November docket is so light? Do you think it's because they think there's a potential they might have to act quickly on post-election litigation?
Right. So what's interesting is that the court sets its docket months in advance. So we say, oh, the November docket's light. This is premised on decisions made 5 or 6 months ago, right, of which cases to grant and when to schedule or argument. So at the end of last term, the justice started granting very few cases. And one sort of theory or one sort of suspicion that I've heard, articulated in different places, is that they were trying to clear the deck, that they were trying to eliminate a lot of the cases that could occupy them once the election begins. And there's no way of knowing in advance which cases those will be. Back in 2020, if you remember, it was a very chaotic period. Justice Ginsburg died. Justice Barrett joined the court on very short notice. You had these appeals from Pennsylvania and other states, and then you had the full, you had Fulton, you had other cases being argued at the same time. It was very, very hectic. So I think for whatever reason, okay, let's just chill out. We'll maybe decide some cases. But the upshot is, November sitting is pretty boring.
Yeah.
I shouldn't say boring. That's mean, because there are lawyers with very important cases to the communities, but there's no really salient hot topic issue that's scheduled.
Exactly. Yeah. So it makes you wonder. And we've already seen just recently, Virginia going to the Supreme Court over trying to remove non-citizens from their voter rolls. And then just the Republicans, the RNC took their Pennsylvania case over provisional ballots to the Supreme Court too. So all this is pre-election, of course, but I guess it just makes you wonder if anything will spill over. I guess I also then will move. The November docket looks a little, like we said, a little light for purposes of talking to an audience that's as wide-ranging. Not, no disrespect to those parties that have the cases before the court, but nothing we're monitoring for my purposes. But December is different. December 4th, there's what I think as of right now could be one of the biggest cases of the term, which is the Tennessee ban on transgender medical treatment, surgeries, that sort of thing for trans minors. And I guess I'll get you just to kind of comment on that case, what you expect or what you anything ahead of time. But also a quick question is, we also have, I think it's still pending cert, was West Virginia and Idaho had sports bills, right? Where they had laws that said biological females only for women's sports. That was both challenged by transgender athletes. That's pending, I think, cert. And so we haven't gotten an answer on whether or not the justices will hear that. Do you think they're waiting to see how the arguments go December 4th in this transgender medical treatment case to then decide whether to take another trans case, or what is trans rights case? What do you take? What do you think? Should we read into this?
Right. So let's do Scrimeti first, and we'll do the other case or pending second. I agree with you that Scrimeti is probably one of the most important cases of the term. And what's significant here is that the court is sort of deciding this in the middle of a election.
Mm-hmm.
And sort of why does this matter? It matters because if Trump prevails, if Trump wins, it's very likely that the government will change a position and say that the Tennessee law is constitutional. And if the court does that, right, I think at that point, the entire thing might flip, right? They might just drop it from the docket altogether. They may say, well, the Tennessee side says it's valid, so is Trump, so where's the controversy? But what sort of complicates things is they have interveners, and they allow there's some private plaintiffs to basically participate in the case. So I'm not sure if the case stays alive.
Okay.
It's actually kind of curious. The second thing to know about the Scarametti case is that they only grant review on the equal protection question, not what's called the substantive due process question. Let me just sort of sketch this out for your listeners. There's two primary arguments of why these laws are unconstitutional. The first is based on the Equal Protection Clause of the Constitution. That is, if a biological male asks for certain medical treatment, the answer is no, because that's part of a transition. If a biological female asks for the same type of treatment, the same type of hormones, that person will be allowed to get it.
Right.
And the argument is this is discrimination on the basis of sex. And Tennessee says, no, that's ludicrous. We're treating boys alike and girls alike. We're not treating them differently. Another argument is called on the Due Process Clause, where there's a fairly deeply rooted tradition that parents have a right to sort of direct the upbringing of their children. It's one of these ancient liberties that we have. And usually it's conservatives who are saying that, the due process right to, make sure our children learn what we want and we're not being indoctrinated. This is a conservative argument. So here you have the children of these transgender kids, the parents of these transgender children, and they're saying, I want my child to get these hormones and these various medical procedures. And the state says, no, this is not safe. We're not going to let you do it. And the question is whether the parents' right to sort of direct their children's upbringing overrides the state's interest in, protecting medicine and health and safety. The court didn't grant review on the due process issue. They only granted on the equal protection issue. So all this really turns on whether this is sex discrimination. What makes this even more complicated is the Bostock case we all know about from a couple of years ago, where Chief Justice Roberts and Justice Gorsuch voted that Title VII, the federal discrimination law, bars discriminating against gays, lesbians, and transgenders, which would have been a shock to anyone alive in 1964. But that's the court reached. So,
the idea was that the protecting a civil rights class like sex means it can also be like sex stereotypes, and that was, I guess, Gorsuch's logic.
Right. It's the idea that when you discriminate against a gay person, the person's sex is a necessary ingredient. That if this person was a man, you'd allow it, but if this person's a woman, you would not allow it, right? The person's sex is a necessary ingredient. And he made that a similar analysis for the transgender discrimination. And that's not exactly the same argument raised by the Protection Clause, but it's in the ballpark.
Mm-hmm.
So again, the conventional wisdom is, of course, Tennessee wins this one, but Gorsuch is somewhat unpredictable on gay rights issues. He's been, since he was a circuit judge, he said there's going to be a soft spot in these issues for gay and lesbian plaintiffs, and I think he ruled in this way when he was in the circuit court in the 10th Circuit, and he's ruling perhaps this way in Bostock. We'll see what he does here.
So you raised the point that if Trump wins, this could change with the Department of Justice in terms of like where the lawsuit is, right? But what about the sports bills? I know that's the DOJ. I don't think are they involved in that too, or is it just the transgender athletes versus these states over their laws?
I just pulled the docket for the West Virginia case. Did the United States file a brief?
I don't have the answer to that question off the top of my head.
I'm looking at the docket. I don't see a brief filed. No, I don't think DOJ would have filed a brief at this stage. It's still a search stage case. Mm-hmm. I don't think DOJ would have filed something. I'm looking at the petition now. The petition was filed in July, and then there were a bunch of amicus briefs filed in August, and then the brief in opposition by the child and the child's mother was filed about 2 weeks ago. So this probably won't even come up for a vote until maybe November or so. I guess they could grant it, but I'm guessing they're going to hold this till maybe January or February if they grant it.
Why do you say that? What makes you think? Just because of like the election or change of administrations or all the different factors?
At this point, if they haven't granted it, we're already, Halloween is coming up, right? It's too late to argue it this year. It's got to be kicked till next year. There's just not enough time.
Okay. What about anything else that you think is worth noting? I know it could change here after the election in terms of what are some of the most interesting cases we're monitoring this term, but anything else that's on your radar that I haven't asked you about that I should have? Right.
So, I mean, the big issue is if Trump wins, does Alito or Thomas hang it up? They decide to step down.
Right.
If Jackson prevails, which is a Democratic Senate, how quickly do they try to expand the court? I mean, we can sort of joke about it, but this stuff can happen very quickly. What could happen in Mexico? It can be done in the span of a few weeks if they eliminate the filibuster, and that's it. And then we'll have 15 justices, and it'll be a lot more hard to do my job.
Yeah, it'll be hard to keep up with. But I appreciate your time. Thank you so much. I'll have to have you back and see what happens after November, and then of course after the December 4th arguments.
Okay, thanks so much, Alex. Talk soon.
Thanks for tuning in to my podcast, Court Watch. If you have not subscribed yet, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.